Good evening, everybody, and thank you all very much for coming along to what is now the third annual Distinguished Lecture of the Centre for Criminal Justice and Human Rights. My name is Ursula Kilkelly, and I took over as co-director with Dr. Shane Kilcummins in January of this year, and we're delighted to be able to present to you a leading international academic in the form of Professor Goodwin-Gill for this evening's lecture. Those of you who are familiar with the work of the Centre will know how committed we are to the highest quality of research and teaching in the areas of criminal justice and human rights. And the annual lecture very much plays a part of that whole process in bringing and teasing out the issues that are pertinent both to law in theory and to law in practice. And so we're particularly delighted to have somebody of Professor Goodwin-Gill's academic and general standing to present the third annual lecture. I'd like to begin by introducing first our chair for this evening, who's Mr. Justice Patrick McCarthy, who is not only a graduate of UCC but also a great friend to the faculty, and I'll leave it to him to introduce our speaker. Thank you very much.
Well, thank you very much, Dr. Kilkelly, and it's a pleasure for me to be here this evening to introduce your distinguished speaker, and also, if I may say so, to say that the Centre for Criminal Justice and Human Rights has shown in the last few years that it has the capacity to attract speakers of great distinction and of great interest indeed. Now, Professor Goodwin-Gill is Professor of International Refugee Law in the University of Oxford, and he's also a Senior Research Fellow of All Souls. Now, he was formerly Professor of Asylum Law in the University of Amsterdam, and he also served as a legal advisor to the Office of the United Nations High Commissioner for Refugees over quite a number of years. He's also President of the Refugee Legal Centre, which is a United Kingdom non-governmental organisation providing legal advice and representation to refugees and asylum seekers. And I notice also that he has appeared, in fact, in a number of cases, including cases in the House of Lords and the Court of Criminal Appeal on behalf of the United Nations High Commissioner for Refugees. So not only did he have practical experience as an advisor for quite a number of years, but he also has practical day-to-day experience, it seems, in the non-governmental area, and then similarly has appeared in court on matters which I think it's fair to say, and certainly I'm familiar with one of the cases, raised issues of serious and high principle in this area. So dare I say it, I suspect it's something which is perhaps rarer than it should be, that he is both a distinguished figure in academic life and also has had the opportunity to appear in the courts, something indeed which happens from time to time here, and obviously is something which, if at all possible, is to be encouraged because of the cross-fertilization, as it were, which it brings. Now, I'm not going to list the extensive series of publications for which he is responsible, or with which he has had an involvement, or indeed a number of publications which he has had in certain Parliament or learned journals. But I do refer in particular, however, to the Refugee in International Law, which is, I think, something which is frequently referred to by practitioners in this area. There is also a further work which I think is of significance or special significance, and that is a work in which he was engaged entitled Forced Migration, Human Rights and Security. It is perhaps the first of those which I certainly have some limited familiarity. I know there's a colleague of mine here this evening who I suspect would have even more. His work has been quoted with approval on a number of occasions in the Irish courts, and whether or not it is quoted with approval, it's certainly used, I've no doubt, by practitioners and by judges in the course of their work. So, ladies and gentlemen, you do have what I would say is, without exaggeration, one of the leading international lawyers, or leading lawyers internationally on the topic of refugee or asylum law to speak to you this evening. And dare I say it, I think, if I might be supposed to say so on behalf of UCC, UCC is very fortunate. So thank you.
Thank you, Judge McCarthy, very much for those very kind, warm words of welcome. I'm delighted to be here. I'm delighted also to be here on the occasion of the launch of Dr. Will's book later this evening. It's a book which touches on an issue which is not far removed from the one I want to address tonight. She addresses the question of protecting civilians in her book, when I want to consider the sort of the more general issue of the extraterritorial reach of human rights obligations. The involvement of European states in peacekeeping and peace monitoring operations around the world, and sometimes also in combat on or in or on behalf of other states such as Iraq and Afghanistan, puts in question the extent to which international obligations of the state travel with it when it ventures abroad. Less immediately controversial operations, such as the interception at sea of irregular migrants and asylum seekers, or measures to control piracy, also invite us to think about the extent to which national forces remain obliged, and more particularly whether those directly affected and injured by their activities have any claim, either under national law or through regional human rights machinery, such as that established by the European Convention. Here we're very much, it seems to me, at the brink of law and power, where policy confronts obligation, where principles of good faith and accountability demand a measure of attention, and where the availability of a remedy for those affected from one perspective might be considered an inappropriate limitation on sovereign power, and yet from another as confirmation of the rule of law. Now, it's common knowledge that the state is responsible in international law for the conduct of its organs, and organs includes, for example, the armed forces. The state is responsible in international law for the conduct of its organs, and it will be liable for that conduct if it is attributable to the state and if the conduct violates an international obligation binding on the state. That's fine in the abstract, but what is less certain is where is that liability to be activated, in which court, in which tribunal, in which other forum. Of course, there can well be municipal law consequences where state organs act contrary to international law. And for this we often turn to the local law to see what it says. And local law may provide remedies in damages against the state, or it may permit the legality of state conduct to be challenged by way of judicial review. Even when the state acts outside its territory, municipal law may still enter the frame. It may again allow an action for damages, or it may permit the criminal prosecution, for example, of members of the armed forces for violations of international humanitarian law, for war crimes. But there is another contested dimension of relevance to the scope of both municipal law and international law, and that is where the state, acting outside territory, violates obligations protecting individual human rights. And there's been quite a lot of litigation on these issues. Claims have been raised for unlawful killing, unlawful detention, illegal surrender, what we in the refugee context call refoulement, and relating to interception at sea. And the defendants, directly or indirectly, have included Canada, Spain, NATO forces in Kosovo, NATO forces over Serbia, and the United Kingdom. In each case, in one form or another, the defendants, the governments in most cases, have argued that the protective law in question, whether it be the Canadian Charter of Rights and Freedoms, or the UK's Human Rights Act, or the European Convention on Human Rights, they've argued that it either does not apply extraterritorially, or to the same effect, that the particular claimants do not, in the circumstances, come within the jurisdiction of the defendant state. Now, though they may shade one into another, the implications at the core of each defense, each objection, are potentially very different. In the one case, the state claims not to be bound by any obligation. In the other, the state admits that it might be bound by an obligation, but says that no remedy is available to the claimant in the particular circumstances. So, for example, we might find the victim of torture at the hands of the military denied the right to claim for the violation of his or her rights, and yet find also that the soldier responsible for that torture may himself or herself be prosecuted for breach of the international rule. So we have to ask ourselves whether a rigid separation of, for example, these two legal regimes, criminal jurisdiction and human rights protection, is justifiable, either on the face of the law or as a matter of policy. Is the state, which is bound by the prohibition on torture, and therefore also bound to take the necessary steps to ensure that its organs do not engage in torture, is it nevertheless free to confine its implementing measures to control and punishment through the criminal law? Or does the principle of effectiveness of obligations in fact limit the choice of means available to the state and perhaps require, as a matter of international law, that individual victims be able, irrespective of their status or location, to claim for injury and loss? Writing in 1995 in the American Journal of International Law, a great international lawyer, Ted Merron, remarked that there was no a priori reason to limit a state's obligation to respect human rights to its national territory. The exercise of power or authority, the exercise of jurisdiction or de facto jurisdiction, he suggested, raised a presumption that the state's obligation to respect human rights continues, and that it should only be rebutted where the nature and the content of a particular right or treaty suggested otherwise. This is a very sound argument, solidly founded in basic principles of state responsibility, and yet it is far from widely or consistently recognized or integrated into the human rights field. Merron himself invites us to look at the nature and content of the particular right, of the duty that is imposed on states. So, for example, the right of every citizen to have access to the public service in his or her country expresses limitations in terms both of the individual, who must be a citizen, and the place, his or her country, in which the right is to be exercised. Likewise, the state party to the 1984 UN Convention on Torture are obliged under Article 12 to carry out an investigation where there is reasonable ground to believe that an act of torture has been committed in any territory under its jurisdiction. Now, while particular treaty provisions may clearly say how and where they apply, human rights treaties also tend to include what I would call general clauses on their intended scope of application, and this is where the problems begin. For example, and I'm sure many of us here today are familiar with this, Article 1 of the European Convention on Human Rights obliges states parties to secure rights and freedoms to everyone within their jurisdiction. Article 2 of the two 1966 covenants requires each state party to respect and to ensure the rights recognized to all individuals within its territory and subject to its jurisdiction. The American Convention, the equivalent provision there, refers simply to all persons subject to the jurisdiction of states parties and makes no mention of territory. And the 1981 African Charter makes no mention of either territory or jurisdiction, although certain rights, such as citizenship rights, are indeed expressed by reference to one's country or community. Now, these provisions, we might, I think, rightly assume, surely exist for a purpose. Now, that purpose may well include the fact that sovereignty and responsibility are territorially based. The state begins from the territory in which it exercises authority, and its sovereignty reflects its competence to act within a defined territory. But responsibility is not at all, and never has been, exclusively territorial. Nonetheless, no state, of course, is responsible for whether or not another state fulfills its own international obligations. So it makes some sense to think of a state's human rights obligations as limited by its territorial boundaries. But again, as Merron has pointed out, there's no a priori reason why the state's obligation to respect human rights should be so confined. And both the UN Committee Against Torture and the UN Human Rights Committee have stressed that what counts over and above or besides territory is power, or factual or effective control. And indeed, if we step away from the treaty context for a minute to the customary international law formulation of particular obligations, the obligation which exists irrespective of whether a state has ratified a particular treaty. If we think about, for example, the prohibition of torture, which is a customary rule of international law, or if we think in a European context of the prohibition on surrendering an individual to another state where he or she faces the risk of the death penalty or execution, then we may well find, we do find, that it is entirely delinked from either territory or jurisdiction. It's rooted, the obligation is rooted simply in the principle of attribution. Now, of course, most days it is indeed the case that the individual's claims upon the state and the state's duties toward the individual will usually have a territorial framework, but the challenge lies in the exceptions, in determining whether and why, if at all, such exceptional cases should be treated differently, and whether or how this has anything to do with jurisdiction. A number of recent judgments in different jurisdictions have indeed attempted to tease out the applicable law where individuals' human or civil rights are claimed to have been violated by organs of the state acting abroad. The Federal Court in Canada, for example, has ruled that the Canadian Charter of Rights and Freedoms does not apply to the detention and surrender to the Afghan authorities of persons detained by Canadian forces acting with the International Security Assistance Force in Afghanistan. The US Supreme Court recently held that statutory habeas corpus protection does not extend to US citizens detained by US forces in Iraq. The United Kingdom House of Lords, on the other hand, ruled in the case of Al-Skaini that while individuals detained by British forces in Iraq were indeed protected by the Human Rights Act and the European Convention, those killed or injured in what I loosely call war fighting were outside jurisdiction and so not protected. And just in December last, the United Kingdom Court of Appeal held in a case on which I was in the legal team, case of Al-Sadoun, that two detainees in British military custody in Basra from 2003 to 2008 did not come within the jurisdiction of the United Kingdom in the sense of Article 1 of the Convention because they were held on the orders of an Iraqi court. It didn't matter for the Court of Appeal that that order of the Iraqi court had in fact been requested by the United Kingdom authorities. In the court's view, given that they were held on the orders of an Iraqi court, there was no basis upon which to say they were within the jurisdiction of the UK, and therefore no basis upon which their surrender to the Iraqi authorities could be resisted, irrespective of any evidence that they might be subject to treatment contrary to Article 3 or to the death penalty. This is a case which continues its path in the European Court of Human Rights, incidentally. The European Court issued an interim measures order on December the 30th, requiring the United Kingdom not to surrender until further notice, which the United Kingdom elected to disregard. Leaving aside the Canadian and US cases, situations involving the possible application of the European Convention have perhaps not been helped by the jurisprudence of the European Court of Human Rights itself. Its pronouncements, quite frankly, are very often difficult to reconcile. Many of you will be familiar, I think, with the leading case of Bankovic, which arose out of the loss of life in Belgrade occasioned by NATO bombing. Those injured and the relatives of those killed claimed for violation of their human rights, violation in particular of Article 2 of the Convention. The European Court dismissed their claims on the ground that the victims did not come, again, within the jurisdiction of the state's parties. I think perhaps it's at that point that we begin to wonder exactly what it is that jurisdiction entails. Now, those who are in favor of a narrow scope of international obligation doubtless rejoiced in the court's emphasis on the fact that jurisdiction, in the sense of the Convention, is in principle territorial, and also that the Convention is primarily for application within the legal space, the espace juridique, which is the geographical space comprising the territory of the 47 states party to the European Convention. And this also contains a certain appeal to common sense too. I mean, after all, what we are talking about is a European Convention on Human Rights, which was drafted under the auspices of the Council of Europe with a view in particular, going back to the 1940s when it was drafted and 1950 when it was adopted, with a view to ensuring that the conduct of European governments thereafter was better consonant with the ideals of the post-war era. Nonetheless, this is where, to some extent, the fun begins, or fun from my perspective, perhaps not from yours. The European Court of Human Rights was also sensitive to the basic principles of state responsibility. And it recognized, nonetheless, having said that in principle jurisdiction is territorial, and in principle it is related to the espace juridique of Europe, nonetheless recognized that convention liability might attach for acts, and I quote, performed or producing effects outside state territory. And it gave some examples. For example, where there was effective control of relevant territory and its inhabitants abroad as a consequence of military occupation, or as a consequence of the consent, invitation, or acquiescence of the government of that territory. Secondly, it said liability might attach where the contracting state exercises all or some of the public powers normally exercised by that government. And then finally it suggested, in a case which still leaves me racking my head, I'm not quite sure, in an example which still leaves me racking my head, I'm not quite sure what it means. They suggested that liability might attach in cases involving the activities of diplomatic or consular agents abroad or on board craft or vessels registered in the state. Now one can see that the first two instances do involve what I would call observable effective control. The contracting state party to the European Convention is in occupation, military occupation of a particular territory. Or it is being permitted to exercise public powers, governmental powers. It has the authority to impose its will. But as I say, the essence of the third exception, diplomatic activities, is less clear. And the question nonetheless is, the question which emerges is whether we can find perhaps a common rational basis to these exceptions, and so come up with some sort of more or less coherent identification of the circumstances in which the protection of the Convention will apply. Now, unfortunately, this is yet another area in which the inherent ambiguities of language seem inevitably to lead to ambiguities of result. And the challenge, I think, is to find the words that do give coherence to the theory and practice of convention protection, and perhaps also to explain, if possible, the precise role of jurisdiction in delimiting responsibility. Although in Bankovich, state acts did produce effects outside state territory, liability was denied, as I have mentioned, on the ground that the claimants were not within jurisdiction. Later, in the case of Issa against Turkey, the European Court did, I think, help to clarify what it understood by the exercise of jurisdiction. It said it is necessary as a condition of responsibility that the state exercise jurisdiction, but responsibility may well attach where individuals, although they are physically present in another state's territory, are nevertheless found to be, as a matter of fact, under the authority and control of the state in the dock. And this approach, again, is unexceptionally consistent with the basic principles of state responsibility, which attach liability through attribution on the basis of the acts of state organs, where those acts in turn are in breach of the state's international obligations. In Öcalan too, Öcalan against Turkey this time again, the court adopted a similar approach, noting that directly after Öcalan was handed over to Turkish officials by Kenyan officials, he was immediately under Turkish authority. This took place in Kenya when he was placed on board a Turkish aircraft. He was therefore, said the court, within the jurisdiction of Turkey for the purposes of Article 1. So far, so good. The essential basis for extraterritorial responsibility can be rationalized, therefore, in terms of attributability, effective control, and public powers. But let me go back to that third category of exceptions. The exceptions comprising or typified by the activities of diplomatic and consular authorities abroad and on board certain craft or aircraft. Now, as a matter of law and practice, if we think about it, it can't be said that diplomatic agents, ambassadors and consuls, exercise effective control over those who enter diplomatic premises, at least not in the same way that an occupying power, a military occupying power, exercises control over territory through the application of authority backed by military force. If you go into an embassy, you do not expect to be treated in the same way as if you go into a militarily occupied territory, and indeed you're not. So why might the actions of diplomatic agents attract human rights obligations? We must, I think, find the answer in some other form of words and think about what it is that diplomats and consuls and others similarly situated actually do. Think about the power or the authority or the competence or the capacity which they have, as does the military, to alter the personal situation of individuals in a way which might violate their human rights. Now, what exactly that covers is a matter of some speculation. Perhaps, for example, if diplomats imprisoned someone on diplomatic premises, they would be liable under the European Convention. I think that probably is a good case, although likely to be rare. But clearly the liability of the contracting state is not contingent here on its being able to implement, for example, the totality of the Convention obligations. Responsibility is tailored to context. Diplomats and consuls can only exercise certain powers in regard to certain people. That would certainly seem to be supported by the reasoning in Bankovic in the second exception, where contracting states exercise in another state all or some of the public powers normally exercised by the government of that state. And this implies, and I think it's interesting in that regard, the convention responsibility, the responsibility of the contracting states can coexist even if the contracting state cannot implement the whole of the convention because one or more areas of public power remain reserved to the territorial sovereign. So that would imply, for example, that United Kingdom forces in Iraq, even though they did not exercise all of the sovereign powers of the state of Iraq, nonetheless were liable within that area in which they did exercise public power, even after an occupation. There's one interesting case that emerged in the Court of Appeal in the United Kingdom, B's case. They found in B's case, the Court of Appeal found that Article 1 jurisdiction liability under the Convention existed with regard to two young Afghan males who had absconded from immigration detention in Australia. You may remember that in the recent past, Australia used to have a mandatory detention policy for all refugees and asylum seekers arriving unannounced in Australia. Woomera was the preferred place of incarceration, led to a number of disturbances. There was a massive breakout at one time, and two of the young men who had been detained there fronted up at the British consulate in Melbourne in search of refuge. Now, although the court arguably in that case applied the wrong threshold test, it accepted that in certain circumstances, Article 3 of the European Convention, which protects against torture and inhuman or degrading treatment, it accepted that in certain circumstances, Article 3 of the Convention would require that these young people not be surrendered or required to leave. For example, if they were at imminent risk of serious injury. And that would be the case whether the risk was immediately due to the actions of another state, in this case Australia, or a non-state actor. So if someone, for example, appeared in an embassy or a consulate fleeing an angry mob. But what responsibility, what pinning responsibility on the officials does here is simply to reflect a much earlier principle, a principle which the European Court had announced in the case of Söring. Söring was an extradition case, but the principle of responsibility of the extraditing country, the country about to send a fugitive back to another place, the liability or responsibility, the court said there, is based upon the foreseeability of apprehended harm outside territory or jurisdiction. And the court said liability is incurred by the extraditing state by reason of its having taken action which has, as a direct consequence, the exposure of an individual to prescribed ill treatment. Söring involves state action with regard to a person who was still, in this case, on British territory and still clearly within UK jurisdiction. B's case takes us into another realm, where we are faced indeed with the actual exercise of a state's competence or jurisdiction abroad. Now, up to this point, my focus has been, as it were, on the effective control of state organs over a particular territory and its inhabitants, or their exercise of public powers vis-à-vis others, or the activities of certain personnel in and against others with whom they enter into contact. But jurisprudence and practice equally recognize another dimension of control authority which exists independently of any actual potential victim, but simultaneously, nonetheless, with the international responsibility of the state. And whereas up to now I've been focusing very much on rights and the duty which states have to respect and to ensure rights, I want to change the focus for a moment, to shift it a little, and move from the rights of the potential claimant more specifically to the duties of the state as a subject of international law. Because I think when we shift that focus, when we begin to concentrate on what it is that the state ought to do, then we can begin to understand more clearly why it is that limitations on extraterritorial responsibility need to be viewed with some suspicion. But here again, the clarity of the picture as we shift our focus is not helped by the judgment of the European Court in another case, Berami. Now, this court arose out of the Kosovo adventure, if you like. One individual had been detained by members of KFOR, the military force sent to Kosovo after its, what should we say, surrender by Serbia. Another claim was based upon injuries suffered by death of one and the injury suffered by a child. As a result, it was claimed of a failure on the part of the French contingent effectively to demine. In the Berami case, contracting states which had contributed troops to KFOR, the military force in Kosovo, avoided being held responsible for alleged violations of the convention. It was never decided whether there were violations. They avoided being held responsible for violations because the relevant acts and omissions, said the court, were attributable to the United Nations and not to individual states. Taking that finding together with the fact that the acts did not take place on the territory of the states in question, the court concluded that the applicants' complaints were incompatible, as they say in their Latin way, ratione personae, with the convention. Now, the case is problematic because it was not argued as it was decided. The respondent states, and many of those which intervened in the case, argued not attribution, not that the acts were not attributable to themselves, but they argued that there was no jurisdiction in the sense of Article 1. But when we look closely at the case, we find that the court is apparently nervous. Its primary consideration was its own competence, broadly considered, whether it had jurisdiction to decide, and whether it was the appropriate forum within which to conduct a review of acts and omissions which had occurred within the context of a UN-authorized international administration. Following the NATO war on Serbia, the UN had authorized the introduction into Kosovo of two components, a civilian presence and a military or security presence. So the presence thereafter of these forces had UN sanction. The court said, though, the question raised in the present case is less whether the respondent states have exercised extraterritorial jurisdiction in Kosovo, but far more centrally, whether this court is competent to examine under the European Convention those states' contribution to the international civil and security presences. The court was clearly very uncomfortable with this role, and although it relied on attribution to the UN, it said that insofar as there was any breach of any obligation, the UN was liable. Although it relied on attribution to the UN as the basis for determining that the applicants did not come within the Convention, effectively and conveniently what it did here was to find a rule, an international rule, limiting its own jurisdiction. So regardless of the merits, regardless of the actual scope of Article 1 of the Convention, the court's subsidiary or indeed subordinate relationship to the UN, which it identified as an organization of universal jurisdiction, barred it from interfering. So if the UN were taken out of the picture, or if the UN's effective authority were less, then that bar presumably would be raised. And to some extent, this is exactly what happened in another House of Lords case, the case of Al-Jeddah, which involved the detention by British forces of some say a dual Iraqi-British citizen, I say a British citizen at the time, although his citizenship has now been revoked. In that case, the House of Lords had to consider whether the action of UK forces in detaining the appellant was indeed to be attributed to the UN or to the United Nations. And the government brought in various UN Security Council resolutions which, after the surrender of Iraq, had provided authorization for the creation of the multinational force and its operations in Iraq. Lord Bingham took up the issue of attribution, and he rejected the suggestion that in the circumstances of the invasion, the occupation, the post-occupation, the UN could be said to have had any effective control over the conduct of UK forces in general and over their specific conduct in detaining the appellant. So he goes straight to the heart of the issue. Which entity, which organization, which authority is competent to determine what UK forces do? And he notes in his judgment, at no time did the UK disclaim responsibility for the conduct of its forces or the UN accept it. It cannot realistically be said that UK forces were under the effective command and control of the UN, or that they were under such command and control when they detained the appellant. I think that is helpful and interesting in the way that it explains what we need to look for when seeking to identify which authority or organ is in fact competent and able to ensure that military or other forces comply with international organizations. In most cases, it will be the national state, sometimes jointly with another party, sometimes jointly with another state or international organization. And the UN itself has long accepted that principle of joint responsibility in the case where it authorizes peacekeeping and other operations, and others and states then contribute contingents to that force. But let me come back to Ted Merron's a priori position. There's no reason in principle why the relevant field of international obligations should not include both international humanitarian law, which we might take for granted where troops are deployed, and human rights law, which may be no less necessary, for example, if international humanitarian law is ruled out or qualified by technical considerations, such as the fact that there is no armed conflict or no occupation. These different regimes depend on the existence of certain facts if they are to come into operation. And international humanitarian law, the war that comprises, amongst other things, war crimes, may not operate in particular circumstances. And that's where human rights law is needed. In these circumstances, excuse me, is there any reason in principle why the individual victims of violations of human rights should not be able to invoke the international responsibility of states in appropriate forums at national, regional, or other level? Policy and executive convenience might say otherwise. But there is no rule of law, no rule of international law, which can explain why the actions of troop-contributing nations are not attributable to the European Convention purposes, but may be for the purposes of general international law. In the Genocide Convention case, Bosnia-Herzegovina against Serbia and Montenegro, the International Court of Justice put its finger on one of the many systemic weaknesses of the international system while nonetheless strongly reaffirming the primacy of international obligation. It recalled what it identified as the fundamental distinction between the existence and binding force of obligations under international law and the existence of a court or tribunal with jurisdiction to resolve disputes about compliance with those obligations. It is a fact that states may be bound, but we may not be able to find a court or tribunal having jurisdiction to determine disputes. The court went on, the fact that there is no such court or tribunal does not mean that the obligations do not exist. They retain their validity and legal force. States are required to fulfill their obligations under international law, including international humanitarian law, and they remain responsible for acts contrary to international law which are attributable to them. Some may be wary of seeking to apply general principles of state responsibility in a human rights context. And although many of us quote the International Law Commissions on the responsibility of states for internationally wrongful acts, it is the case that they do not provide a complete picture. They do not encompass the situation where the rights holder in question is, for example, an individual. They leave open the precise consequences of breach where the primary beneficiary is not a state, as in a human rights case. And in my view, it is precisely here that human rights law considers also as the law which attaches to various universal and regional regimes must come in to fill the gap. The concept of jurisdiction, as it's used in the European Court of Human Rights and in some national jurisdictions, is problematic, particularly when we look at claims arising from the extraterritorial acts and omissions of the state. It is most usually used, when we talk about jurisdiction, we most usually are thinking about something else in general international law. We're thinking about the legal competence of the state. The state has jurisdiction, judicial, legislative, and administrative. This is a consequence, an aspect of its sovereignty. But as Ian Brownlee, my former tutor and supervisor, notes in the 7th edition of his basic work, Principles of International Law, jurisdiction also includes enforcement or prerogative in jurisdiction, namely, and I think he encapsulates it well here, the power to take executive action in pursuance of or consequent on the making of decisions or rules. And that's what we see in particular when the state leaves its territory and ventures abroad. It is this sense of jurisdiction which stands out in human rights claims arising out of those extraterritorial actions. It is clear then that in principle, human rights obligations are capable of binding the state when it ventures abroad. Whether they do and what are the consequences depend first on the nature and content of the primary rule establishing the obligation, and secondly, on whether the claimant comes within the scope of that rule, and thirdly, on whether the injury or the act is attributable to the state. An attribution in this sense links the acts of state organs to the legal responsibility of the state itself. In most cases involving state organs, in most cases involving actions by the military or the police, attribution is indisputable. Those organs of the state render the state liable whenever they act. Not even excessive authority or contravention of instructions suffices to break the chain. What the European Court of Human Rights needs to do, what national courts need to do, therefore, is to look beyond the formal terms of Article 1 and, as Ted Merrin suggested, to the content of the obligation in the particular case, considered in the light of the object and purpose of the Convention. So Article 3, the prohibition of torture or cruel or inhuman or degrading treatment, is manifestly capable. It can be fulfilled by state organs wherever they act. The military doesn't have to torture when it ventures overseas. Other articles, such as Article 2, the right to life, Article 4, the prohibition of slavery, Article 5, the protection of liberty and security, may also be capable of being implemented in and subject to the limits of particular scenarios of extraterritorial operations. This indeed is what the House of Lords found in Al-Jeddah. Human rights law requires that the individual be protected, and whether the state is responsible for the failure to protect depends on whether its actions are the cause of the injury. In this context, the fact that the state exercises control, authority, or custody over the individual provides the necessary nexus. It's no answer, it seems to me, to say that the overall purpose of human rights protection is fulfilled by parallel measures such as war crimes legislation, international criminal law, or courts martial. For these, sadly, have proven inadequate to the purpose. For those of you who know the facts of Al-Skani, you may know that the one individual in that case whose case succeeded Baba Musa had been beaten to death by British soldiers. Those believed to have been responsible were court-martialed. The court-martial fell apart. Only one person who admitted guilt was convicted and sentenced to imprisonment. The judge at the court-martial referred to a closing of ranks and also criticized the quality of the investigation. So courts-martial very often do prove inadequate to the purpose. In my view, not only must responsibility for human rights violations be recognized at the international level, but human rights claims also require adjudication if executive action, that enforcement and prerogative jurisdiction, is to be kept within the rule of law. So it seems to me that jurisdiction, if it is to have a coherent meaning, I mean, I would like to get rid of it in this context, but I can't, I have to work with it. If it is to have a coherent meaning in the context of human rights protection, it should therefore be seen to reflect that aspect of the term in general international law which recognizes that every state has the sovereign capacity to act outside its territory, while leaving open, of course, the question whether the exercise of jurisdiction is in fact lawful vis-à-vis other states, or whether it is consistent with human rights obligations. The espace juridique to which the European Court referred in Bankovic is not, in my view, just about enforcing rights in a particular regional or territorial context. It's also about values, as the principle of the Convention makes clear, and as the Court itself has frequently emphasized. It is about obligations, if not at large, erga omnes all the world, then at least towards those touched by European state conduct beyond European state territory. Obligations, the impact and consequences of which do not depend and are not contingent for their realization on any discrete territorial link, which rather reflect the responsibility attaching in the normal course of events to conduct, power, authority, and control over the lives of others. Only, it seems to me, if we move in this direction, can we be sure that executive conduct in the future internationally may become subject and kept within the rule of law. Thank you.